The state of Iowa. Are you all, you're
Yeah.
here and you're ready? Good. The Project Resolve for Special Education with Kurt Sitzma and Connie Faslow.
On behalf of the state of Iowa, the Governor's DD Council, and the Legal Center for Special Education, I want to thank you for this opportunity. Bonnie and I decided to divide the labor the way we do back home. As the lawyer, I'm primarily responsible for active advocacy. As the executive director, Connie's primarily responsible for making sure I don't mess up. Parents of children with disabilities in Iowa, as in the rest of the nation, face extraordinary difficulties advocating for the needs of their children, educational and related, especially in cases where the school districts, for financial or other reasons, are not responsive. School districts almost invariably have access to the best firms in the state. Parents sometimes, for no money, can find someone with expertise. In the fall of 2000, Connie and I got together and we presented a rather bold proposal to the Governor's Council on Developmental Disabilities. We said that we could create a system that served every parent who needed advocacy assistance with expert legal advice. We could do it for the entire state of Iowa, and we would do it if they'd give us a startup grant of $60,000. We said we could do that because there's a couple of concepts. Number one, philosophically, we are committed to the proposition that the best way to resolve parental concerns with school is through conflict resolution at the lowest level of conflict possible. If you can talk the school into giving you half a loaf voluntarily, it's 10 times better than the whole grocery store ordered by a judge. That philosophy reduces our input. Second, we work with paralegals a great deal. Connie is a paralegal. What we wanted to do is take the parent organizations who are already there, actively advocating, but without legal advice. Give them the legal advice and benefit from their strength and their outreach in all the communities. We've had assistance following that initial $60,000 grant, including the continuous support of the Iowa Department of Education, and then the U.S. Senate has made us a national pilot project, which helps significantly. What I want you to know is what we've accomplished with a sum that is relatively paltry compared to most of the things that you consider when you think of government, even big government. Right now, we represent 90% of all the parents in special ed cases anywhere in the state of Iowa, and I can guarantee you they get expert legal advice when we do it. The second thing that I can tell you is our numbers on conflict resolution are such that we have 500 parents that we will assist through direct or indirect legal advice. Only 35 will go to pre-appeal. Only 1 or 2 in conflict resolution will go to an actual litigation in a year. Perhaps 3, but far less than 1%. Judy Schrag, who used to head OSEP, was in Iowa for consultation, and she told us our numbers for conflict resolution are the very best in the nation, which means we produce a win-win for the parents, for the school, and we save the public far much more than we ever would cost. If I could give you an example of the kind of things that we get to do because we've developed this expertise, I'm going to pretend his name is Justin because that's my son's name and we have to be confidential. Went to a small town where the boy is ready to drop out of school. The boy is so distressed and he's flunking out. The school is upset with him. The mother is frantic. They have had a series of meetings and they're at each other's throat, and I'm told it can't be fixed. I read the record and I explained to the school in our pre-appeal conference, this is only a process that takes a few hours, how you could approach his learning disabilities differently. I watched the school change its mind. I watched the principal and the superintendent say, you know, we could do that a little different. Within months, that boy was graduating again, the family is restored, the relationship is good, and he's going to be a chef someday as soon as he graduates. It is going to happen. And that's not just one of those. There's many. And if I could tell you something that personally inspired me, it fits here all through school. I had this poster, a poster on my wall, and I want to say what it said. Paraphrased, some people see things that are and ask why. Some people dream things that never were and asked, why not? Why not do more of this across the nation? Thank you.
Carl.
Well, first, Mr. Sitzma, on behalf of the Attorneys Anonymous caucus, let me just thank you and congratulate you for your efforts. My understanding is that you literally yourself handle all of the legal representation throughout the state for this program. Is that correct? And what would happen if you were not available?
Our goal from the beginning is to make this position sufficiently attractive that I can be readily duplicated. I have 2 attorneys who have volunteered with us. I have a lady who is volunteering and driving 60 miles, is going to go to law school. She drives 60 miles to get to us twice a week because this is her long-range goal. The helping can be done. And I'll tell you something about being a lawyer. You test 2 things out so you can get it done with lesser money. Tell people you're an attorney when you're a stranger, and tell them you're an attorney for kids with disabilities. And you got a gap there in terms of self-reward that's pretty big.
Susan?
Tell me, I was looking through your application for results data, and you don't have as much in there in the way of quantitative or qualitative data that some other applications have, but it's clear you have a lot of successes to take credit for. If you were starting your program over, can you help us think through what we would be measuring, either Iowa versus other states, what's going on in other states, or where Iowa started and where you are now, just in terms of addressing and resolving these issues for students with special needs?
Well, I think we would certainly measure, compared to other states, the amount of litigation, and there's clearly a big difference there. But we came up with this idea because Iowa already had instituted a proceeding that we call a pre-appeal, which is something that doesn't exist in other states, but it's under the federal law that due process hearings and more adversarial actions are done under, except it is a very mediation-like, very communication-building type of process, or at least it can be used that way. And that sort of allowed us to come in and be the legal clout behind all of the advocates who had been working with parents and on behalf of parents, but who sometimes got dismissed as just, another layperson who doesn't really know what they're doing. And by working with them, we give them the legal clout to know that they've got accurate information, and that if they are not successful, that we still have the ability to come in and do the more adversarial processes.
Okay, Bill, and then Maria, did you want to add something to that, Mr.?
That's fine.
Bill Klinger?
Well, I think you're to be commended, really, for shifting the emphasis from the adversarial relationship to a concentration on what is really good for the child, what is the welfare of the child called for here. It seems that this is somewhat similar to a program in California that I think I wanted to get your sense of how you differentiate your program from the California experience.
I wouldn't, because I'm not familiar. This was homegrown in our approach, and it isn't just the non-conflict. I couldn't do it. We couldn't do it for the kind of monies or anything reasonable, given how the economy is lately, especially for government programs. We couldn't do it without the relationship through the parent intermediary organizations. I should hope that the concept of let's resolve it for the sake of the kid at the lowest level of conflict is an instant sell, at least verbally. If you walk that talk is another matter. But the idea of let's take limited legal expertise, this amount, and leverage it through a whole system of parent advocates who've got all the heart in the world, if you give them the way to do it, to make it work. That is the true innovation. And I don't believe that's been done in California, with due respect to every Californian in the room.
Of whom there are a lot. Maria, last question.
There are some jurisdictions in which the plaintiff's bar, if you will, for children with disabilities it's a cottage industry. And so how could you replicate this in a jurisdiction in which the school district has a mindset that getting lawyers involved, even at a pre-conflict, is just not to be done?
It's one reason. The question wasn't asked, but would I advocate getting rid of the fee-shifting statute? And the answer is no. I don't like to have to use it, but sometimes the best way to prevent war is be prepared to go to war and to let them know. It means that if you're going to replicate it in a state where the school attorneys are not respectful of the rights of parents, your first step is to prove to them that they need to be respectful. You have to win a couple of cases. Then you be reasonable, back down and work the other system.
And to prove to parents that half a loaf of bread that the school gives voluntarily is better for them in the long run than the whole shopping cart.
Mr. Sitzman, when you return to the county school, we hope you will bring your poetry with you. In the meantime, thank you both very much.